my property. I don't have to move.
I don't care who you are. Hands now.
I'm a retired judge. This isn't right.
Enough talking. Move.
The doorbell is recording you. Stop this.
At 6:42 p.m., a doorbell camera clicked on, not to record a crime, but to preserve one. A man stood barefoot on his own porch, deed papers inside the house behind him, the law quite literally under his feet. He spoke calmly. He cited rights. He asked for a supervisor. The officer didn't listen. By the time the red recording light shut off, the arrest was already irreversible. Not for the man in cuffs, but for the badge that ignored him. Stories like this don't just disappear into court records. They shape how power is trusted or feared. If you care about accountability, about what happens when authority stops listening, stay with this story. It unfolds quietly, and then it changes everything. The porch light was already on when the cruiser pulled up, washing the front of the house in a dull amber glow. It was early evening, not quite night, but late enough that shadows had begun to stretch across the lawn. The doorbell camera blinked red, steady, impartial. It had been installed months earlier after a package theft down the street. No one imagined it would one day record something far heavier than a missing box. He stepped outside barefoot, the screen door closing softly behind him. The wood beneath his feet was familiar, worn smooth by years of quiet routines. Mornings with a newspaper, evenings with tea. This was not a man accustomed to shouting across property lines. His voice, when he spoke, carried the calm of habit, not fear. "Yes, officer," he said. Hands visible, posture relaxed. "How can I help you?" The officer remained at the edge of the porch, one foot on concrete, one on grass. That boundary, invisible but absolute, had legal meaning. Private property, no exigent circumstances, no warrant. The judge knew this instinctively, the way some people know the feel of weather before rain. Decades on the bench had trained him to hear what wasn't being said. "We received a call," the officer replied. His tone was flat, procedural. "I need you to step down here so we can talk." The judge glanced briefly at the steps, then back up. "I'm happy to talk right here," he said. "This is my property." It wasn't defiance. It was clarification. The officer exhaled, a subtle shift in weight. "Sir, I'm asking you to come down here." "Asking isn't ordering," the judge said gently. "And you don't have probable cause to detain me." That was the moment. Not dramatic, not loud, just precise. Training doctrine, drilled into recruits at the academy, is clear on moments like this. Presence and control do not equal authority. Authority comes from lawful basis, clearly articulated. The officer had been trained on this. He had passed the exams. But training often fades under the pressure of being watched. The radio crackled softly at his shoulder. Somewhere else in the city, another call was waiting. "I don't want this to become a problem," the officer said. "Neither do I," the judge replied. "That's why I'm asking you to respect the law." A pause. The kind that feels longer on playback than it does in life. The officer stepped closer to the porch. Not onto it, not yet, but close enough that the boundary blurred. His voice sharpened. "If you don't step down here, you're obstructing my investigation." The judge's eyebrows lifted slightly. A flicker of disbelief, quickly masked. "Obstruction requires an underlying lawful order," he said. "You don't have one." That sentence, clean, accurate, unraised, carried more weight than shouting ever could. It was also, unintentionally, a mirror, and the officer did not like what it reflected. Neighbors' curtains shifted. Someone across the street paused mid-walk, phone half-raised. The doorbell camera kept recording, capturing the subtle tremor in the officer's jaw, the way his hand hovered closer to his belt. "Sir," the officer said, slower now, louder. "Last chance." The judge didn't move. He didn't need to. His feet were planted in legality, even if the moment no longer felt stable. "Call your supervisor," he said. "This doesn't need to escalate." For a brief second, it almost didn't. The officer hesitated, eyes flicking away, as if searching for an exit that preserved dignity. Then pride filled the silence. The radio stayed quiet. The porch light buzzed faintly. "All right," the officer said. "Turn around." The words landed heavier than a shout. Somewhere inside the house, the deed to the property sat in a filing cabinet. Somewhere in statute books, the law was unambiguous. But on that porch, momentum had begun to outrun reason. The officer stepped onto the wood. The property line disappeared. The first click of the handcuffs didn't come immediately. There was a delay. A procedural pause that should have mattered more than it did. The officer's boot pressed into the porch boards, testing weight, testing control. The judge turned slowly, deliberately, as instructed, his hands folding behind his back without resistance. His movements were careful, almost ceremonial, as if he were reminding both of them what compliance actually looked like. "This is unnecessary," he said quietly, not pleading. Observational, the way one might comment on an approaching storm already too close to avoid. The officer didn't respond. Silence can be a strategy. It can also be a shield. Department policy requires articulation before restraint, a clear statement of cause, an explanation the subject can understand. The body camera would later capture the absence of it, a gap filled only by the scrape of metal and the hum of the porch light. The officer's jaw tightened as the cuffs closed, not roughly, but firmly enough to erase any illusion of choice. "Place your feet together," the officer said. The judge complied. From the street, it looked orderly, controlled. That's often how mistakes survive their first inspection. There was no struggle, no raised voices, nothing that would trigger immediate alarm. Just a man being arrested where he shouldn't have been, and an officer crossing a line he could no longer see. "Am I being charged?" the judge asked. The question hung there, unanswered. The radio crackled again, louder this time. "Dispatch requesting status." The officer turned slightly away, voice clipped, professional. "One detained. Requesting backup. Detained. Not arrested." Language matters. It always has. Backup arrived within minutes, another cruiser pulling in, headlights flaring across the lawn. A second officer stepped out, younger, eyes scanning the scene with a quick calculations of someone deciding how much to ask and how much to accept. He glanced at the cuffs, at the porch, at the judge's posture. There was a flicker of hesitation. "What's the charge?" the second officer asked, low. "Obstruction," came the reply. Immediate. Unexamined. The judge turned his head just enough to meet the younger officer's eyes. "I'm on my own property," he said. There was no lawful order. That should have slowed things down. Supervisory doctrine emphasizes pause when legal ambiguity is raised, especially by someone calm, compliant, and informed. But ambiguity is uncomfortable. Pride fills the space where questions live. "Sir, you need to stop talking," the first officer said. "I'm allowed to speak." The judge replied. "I'm also allowed to stand here." The younger officer looked away. The patrol car door opened with a hollow thunk. Vinyl seats, faint disinfectant. The small, unremarkable details that make moments like this feel routine and therefore justified. The judge was guided, not forced, his head ducking instinctively as he was placed inside. No resistance, no sudden movements, the kind of arrest departments like to point to when defending outcomes. But procedure doesn't end with control. It begins there, inside the cruiser. The judge shifted his wrist slightly, testing the cuffs. They were tight, within policy limits, but close enough to remind him he was no longer the one asking questions. Outside, the officers conferred in low tones. The word supervisor surfaced, then vanished. No call was made. The report would later describe the judge as uncooperative. That word, elastic, vague, has protected more mistakes than any shield ever could. It suggests behavior without defining it. It implies threat without evidence. As the cruiser pulled away from the curb, the doorbell camera continued recording. The empty porch, the lights still on, buzzing faintly into the evening. The property line, once clear, now meaningless. In the front seat, the officer stared ahead, hands steady on the wheel. This wasn't anger anymore. It was commitment, the kind that forms when backing out would require admitting something had gone wrong. Behind him, the judge sat quietly, watching the neighborhood recede through the glass. He had spent years believing in procedure, not as an abstract idea, but as a safeguard against exactly this. Tonight, procedure hadn't failed loudly. It had failed politely. The booking desk smelled faintly of disinfectant and old paper, the kind of institutional scent that never quite leaves your clothes. Fluorescent lights flattened everything beneath them, erasing shadows, erasing nuance. The judge stood where he was told, cuffs still on, shoulders squared, not in defiance but in dignity. If the officers noticed, they didn't acknowledge it. "What's the charge?" the clerk asked, fingers hovering over the keyboard. The officer paused, just long enough to register on the body cam. "Obstruction," he said again, less certain this time. "Underlying offense." The clerk pressed, not looking up. Silence stretched. A second officer shifted his weight. Somewhere down the hall, a phone rang and went unanswered. He refused to comply with lawful commands, the officer said finally. The judge exhaled slowly. There were no lawful commands, he said. Calm, even now. Policy manuals are explicit at this stage. Arrest requires probable cause supported by articulable facts, not conclusions. The clerk's fingers hesitated, then moved anyway. Systems are built to process inputs, not challenge them. Once the charge field is filled, momentum becomes infrastructure. The cuffs came off for fingerprinting. The judge flexed his wrists slightly, feeling the ache settle in. Not pain, just the dull reminder of metal where trust used to be. The technician avoided eye contact, focusing instead on the ridges of inked fingers pressing onto glass. Each print captured cleanly, permanently. Any medical conditions? The technician asked, reciting. No, the judge replied. Just decades of believing this wouldn't happen. The words landed softly, unnoticed by anyone who could have heard them. In the holding area, time slowed. Concrete bench, scuffed floor. A low hum from ventilation that never shut off. The judge sat alone, hands folded, posture unchanged. He replayed the porch in his mind. The phrasing, the pauses, the precise moment when law stopped mattering. He knew the statutes by heart. Trespass requires entry onto another's property. Obstruction requires interference with a lawful duty. Neither existed there, not even close. What existed was escalation without anchor. A supervisor arrived eventually, summoned not by concern but by procedure. He reviewed the report on a tablet, scrolling, nodding again. Looks fine, he said without looking up. Did you watch the footage? The judge asked. The supervisor hesitated. We'll review everything later. Later is where accountability often goes to rest. Release came quietly, without apology. A signature, a court date that shouldn't exist. The judge stepped back into the night, air cool against his face, the city unchanged. The same porch light still glowed in the distance when he returned home, casting the same amber circle on wood that now felt unfamiliar. Inside, he sat at his kitchen table and opened his laptop. He didn't call a lawyer yet, he didn't call the media. He opened the doorbell app. The footage loaded slowly. Frame by frame, the encounter returned. The officer's foot at the edge of the porch, the shift in tone, the exact second authority replaced legality. It was all there, clean, undeniable, the kind of evidence courts rarely get. By morning, the video had been saved in 3 places. By afternoon, it had been shared once, cautiously, with someone who understood both law and consequence. And by evening, the arrest, that shouldn't exist, began to collapse under its own weight. The officer, meanwhile, finished his shift believing the hardest part was over. Reports filed, narrative set, another call answered. He didn't know yet that the camera he had ignored was already doing its work. Slow, patient, unforgiving. Some arrests end at release. Others don't really begin until then. The video didn't explode onto the internet the way people imagine these moments do. There was no overnight outrage, no trending hashtag by sunrise. Instead, it moved the way uncomfortable truth often does. Quietly, through channels built for damage control rather than justice. First, it landed on a supervisor's desk. Then legal. Then internal affairs. A conference room screen flickered to life. The footage played without commentary at first. Policy requires that. No framing, no defense, just time, sound, and choices preserved exactly as they happened. The room was filled with people who had worn the badge long enough to recognize the danger before it fully arrived. There was the porch, the boundary, the request to step down, the refusal calm, reasoned, lawful, the escalation. Someone paused the video. Rewound 10 seconds. Played it again. That's his property, one of the attorneys said. Not as an accusation, but as a statement of fact. No one disagreed. Training bulletins surfaced from digital archives. Use of authority guideline. De-escalation mandates. Constitutional refreshers required annually. One line was read aloud, almost involuntarily. Officers shall not issue commands absent lawful basis. The silence that followed wasn't defensive. It was clinical, a kind that settles when everyone understands the outcome before it's announced. Meanwhile, outside the building, the story began to leak, not through activism, but through verification. A reporter filed a public records request. A civil rights attorney requested the footage under state disclosure law. The department's press office drafted a statement and discarded it twice before settling on something carefully hollow. We are aware of the incident and are reviewing the matter. Reviewing is what institutions say when they already know. The officer was placed on administrative leave, paid, pending investigation. Standard procedure, neutral language, but inside the locker room, everyone understood the difference between routine review and isolation. Conversations softened around him. Eye contact shortened. No one asked how he was sleeping. At home, he watched the footage for the first time on his phone, alone, without briefing notes, without colleagues to buffer the impact. He saw himself from the outside. The pause, the tone, the step onto the porch. He watched the judge's stillness, the composure that now felt accusatory in hindsight. It didn't look like threat, it looked like control being challenged. That realization landed heavier than any public criticism could have. In law enforcement culture, mistakes are survivable, ego injuries are not. When the footage finally aired, it wasn't sensationalized. No dramatic music, no edits, just the video raw and uninterrupted. Viewers didn't need commentary to understand it. They recognized the imbalance instinctively, the way power leaned forward while restraint stood still. Public reaction followed a familiar arc: disbelief, anger, exhaustion. But something else surfaced too: recognition, not of a rare abuse, but of a common one, caught clearly enough that it couldn't be explained away. Inside the department, policy memos were drafted faster than usual. Property rights, refresher training, mandatory supervisory call-ins for contested detentions, language tightened, expectations clarified. These were not reforms born of vision, but of necessity. The judge declined interviews at first. When he finally spoke, it wasn't with bitterness. "I wasn't arrested because I broke the law," he said. "I was arrested because someone stopped listening to it." That line traveled farther than the footage. The officer received notice of a formal finding: violation of constitutional policing standards. The words were precise, unemotional, career-altering. He sat in his car afterward, engine off, dashboard dark, replaying the moment he could have stepped back, the moment he didn't. Playback has a way of doing that, returning choices without urgency, without pride, stripped of adrenaline, just decisions, standing naked in fluorescent light. And now, there was only one question left unanswered: what happens when authority is proven wrong? The consequences didn't arrive with sirens or shouting. They came the way institutional endings usually do, quietly, in envelopes and calendar invites, in conversations that avoided the word discipline while circling it carefully. The officer was called in on a Tuesday morning. The room was smaller than the conference room where the footage had first been played, but it felt heavier. Internal affairs sat on one side of the table, legal on the other. No uniforms, no raised voices, just findings. The language was exacting. Lack of lawful basis, failure to de-escalate, improper arrest on private property. Each phrase landed with the dull weight of something that couldn't be appealed emotionally. The department cited Supreme Court precedent, Fourth Amendment protections, established clearly, violated plainly. This wasn't a gray area. It never had been. Resignation was offered as an option, not officially framed as one, more as a way to move forward. The officer understood the subtext immediately. Termination would follow if he refused. His badge, his firearm, his authority, all of it already functionally gone, he signed. There was no press conference about his departure. Just a line added quietly to a monthly personnel report. Years of service reduced to a paragraph that avoided naming the reason. In law enforcement culture, this is how careers end when they can't be defended but still need to be buried neatly. The judge's case dissolved faster than it had formed. Charges dismissed without explanation, as if the arrest had been a clerical error rather than a constitutional breach. No apology was issued. None was requested. Vindication doesn't always feel like triumph. Sometimes it feels like fatigue. At a city council meeting weeks later, policy revisions were approved unanimously. Mandatory supervisor response for disputed detentions. Clearer language on property line encounters. Annual constitutional review tied to certification renewal. The reforms were tangible, measurable, the kind institutions prefer, because they can be tracked. But policy can only correct behavior it's allowed to see. The judge returned to his porch one evening just as the sun dipped low enough to cast long shadows across the steps. The light buzzed on automatically, the same as always. He stood there for a moment, barefoot again, feeling the grain of the wood beneath him. The boundary was still there. It always had been. He thought about how close the law had come to failing quietly, how easily this would have disappeared without the camera, how often it probably already had. Justice, he understood now, doesn't announce itself when it works. It endures in systems that admit error, and in people willing to press record. Somewhere else in the city, a new officer was being trained. the same statutes, the same procedures. But now, included in the curriculum was a video, a porch, a pause, a decision. Authority, when stripped of accountability, costs more than careers. It costs trust. And trust, once broken, is the hardest thing to restore, even when the law is finally on the right side of the line.